Well, good afternoon, everyone. Thank you for being here. We're delighted that you're here for our symposium entitled Laboratories of Democracy, Administrative Law in the States. My name is Ben Ponce. I am the Vice President of Speakers for the Harvard Federalist Society, which I suppose I should note as a footnote, stands for three main principles: that the state exists to preserve freedom, that the separation of powers is central to our Constitution, and that it's emphatically the province and duty of the judiciary to say what the law is and not what it should be. We're really pleased to be doing today's event in partnership with two other institutions, the Harvard Journal of Law and Public Policy. I want to thank Mario and Kyle in particular for their work putting this together, and also I'm going to try and do this all in one breath, the Boyden Gray Center for the Study of the Administrative State at George Mason University's Antonin Scalia Law School. And our friend Adam White, who's really been kind of the instrumental motivating force on whose coattails we're all riding this afternoon.
Ben, I'll just interrupt and say that was great. About 50% of the time it gets introduced as the Center for the Administrative State. I always say affectionately, though, that's probably at Harvard Law School.
Indeed, and I guess I did mention in October we had Adam's co-executive director, Jennifer Mascott, here for our event on major questions doctrine. And I promised then that you would meet Adam soon, and so now you've met Adam. Okay, great. So let me introduce our great panel today. Judge Thomas Griffith, retired from the DC Circuit and a familiar face to many here from his winter term course, will be our moderator. To his left, my right, is Justice Caleb Stegall from the Kansas Supreme Court, and then Justice Brian Hagedorn from the Wisconsin Supreme Court on the end. And then to Judge Griffith's right, my left, is Justice David Wecht, who hails from America's greatest commonwealth, that of Pennsylvania. Thanks, Brian. I swear I didn't plant these applause lines. And then finally, we have Judge Jeffrey Sutton, the Chief Judge of the United States Court of Appeals for the Sixth Circuit, and a state constitutional law enthusiast, to say the least. And many folks in this room are also in his winter term class, perhaps myself included. Not perhaps, myself included. So with that, I'm going to turn it over to Judge Griffith, and off we go. Thanks for being here, everyone.
Thanks, Ben. Thanks, Ben, and thanks to everyone for coming. Adam White and Judge Sutton have a talent for forcing us to return to first principles, and they have done so again today with this symposium on administrative law in the states. We start with the most basic principles of the separation of powers, which is the most basic feature of the national government the Constitution created and of the Republican governments the Constitution requires of the states. First, law is created by a legislature accountable to we the people. Second, it's the duty of the executive to take care that law is faithfully executed. But now is where it gets interesting. Who decides the contents of that law? You'll notice a number of times today I use the phrase "who decides." It's a subtle plug for Judge Sutton's book, which is available on Amazon.
No reason to
Where it gets interesting is who decides the contents of the law. That's the rub. In carrying out its faithful execution of the law, the executive must interpret the legislature's command. That's unavoidable. And when it does, what role does the judiciary play in reviewing that interpretation? At the federal level, there are few, if any, more consequential questions to be answered. Answering that question, determining the role of the judiciary vis-a-vis the executive in interpreting the legislative command, determining who decides, calls for a deep understanding of the purposes of the constitutional structure. And as Justice Scalia reminded us again and again, that structure, which separates legislative, executive, and judicial functions, is not only the great innovation and the hallmark of the Constitution, it is also the greatest guarantor of the liberties the Constitution protects. We are convened today to see how this question of who decides the content of the law is playing out in some of the states. As Judge Sutton reminds us again and again, what is happening in the states is vital not only because they are laboratories from which the national government can learn, but they are the governments that have the most pervasive influence on we the people. As we shall see, some states have different approaches to the separation of powers, that have been taken at the federal level owing to their differing constitutional structures. Some have statutes that spell out the role of the judiciary in administrative matters in a more direct fashion than do acts of Congress. Some states have developed a body of case law under the rubric of the separation of powers that emphasize different points than those that have occupied the attention of the federal courts. It is the hope of this panel that our exploration of the differing approaches to the role of the judiciary in administrative law that is going on in the states will help us be better equipped to answer the all-important question the Constitution takes most seriously: who decides? So we have decided randomly, somewhat, we decided to hear from the justices in alphabetical order of the states in which they serve. Does that work? So I believe that means that we are going to start on my far left with Judge Stegall from Kansas.
Yes, right here.
Oh, I'm sorry.
To your near left.
To near left, okay.
I was going to say we're about to elevate Wisconsin in the alphabet. Sorry, any other way. Greetings, it's a pleasure to be here. I've really enjoyed my brief time here already. When Adam invited me to participate in this event, Kansas, as many of our states, was in the throes, of course, of a heated electoral cycle. And we had several constitutional amendments placed on our ballot by our state legislature, and one of them was directly related to the subject of administrative law. So it was a happy coincidence that when Adam's invitation came in, I started receiving at my house multiple glossy mailers with very large, scary words on them that said, unelected bureaucrats make whatever regulations they want. And in order to stop this, the publicist of this glossy mailer told me that I needed to vote yes on a proposed constitutional amendment because that was the only way I could, quote, give every Kansan a voice in state government. So as you can imagine, this particular amendment was intended to restrict the administrative state in Kansas. I think that it's fair to say that the folks who worked to get this amendment on our ballot were mostly upset with the administrative actions of our governor, Governor Laura Kelly, that she took during the COVID pandemic. I think that was probably the motivating factor to once again try to push back against these unelected bureaucrats making whatever regulations they want. The amendment would have given a legislative veto over executive branch regulations. It failed by a few thousand votes in Kansas, which I think just proves that the issue is alive and well across the country in our states. I wanted to start with that and highlight that because it does really encapsulate in a nice pithy way this crucial question of administrative law, right? Who decides? The mailer also frames the question for us in what I think has been the most common for political framing, which is it's either the good American citizens functioning in a self-democratic way, making the laws through their elected representatives, or it's the evil bureaucrats, right? And that's obviously one perspective that this question gets approached with. To put it in more scholarly terms, one recent article described the administrative state as a, quote, extra legal regime because it has the capacity to, again, quote, evade not only the law but also its institutions, processes, and rights. The central evasion is an end run around acts of the legislature and judgments of the courts by substituting executive edicts. So that's the criticism, right, of the executive, of the administrative state. And the reason why, at least on my court, and I trust on many courts around the country, we get these cases that ask courts to draw the right lines, to say really who gets to decide in these disputes between branches of government and public officials. It's complicated, of course, because judges themselves, we are also public officials serving in one branch of government, and oftentimes we may be accused of treading on the powers of the other branches. In my short comments at the outset here, I thought to talk about Kansas and what has happened in Kansas, I would focus on one area of administrative law that I think does not actually get much attention in the broader discussion. I think we're going to talk some about deference here. We'll probably talk about non-delegation and so on. And Kansas certainly has had its has its rules with regard to those things. But we have had some interesting cases recently in the arena of prosecutorial discretion. And I don't think this gets folded into the question of administrative law very often. But I actually believe that prosecutors are some of the most important administrative officials, executive branch officials, officials that execute administrative law in our society. And the criminal statutes are often written in very broad ways, which allows prosecutors to exercise tremendous discretion in how they apply those statutes. So the question is this an unconstitutional delegation, or is there ever a way for a legislature to unconstitutionally delegate its power to define crimes to the executive branch? And we've had two interesting cases in Kansas recently that have sort of put that issue front and center for us. I'll just briefly recite the facts because I thought they were fascinating when the cases came to us. In one, a couple guys out in the country were having fun, drinking beers, playing around with their guns, and decided to put some gunpowder in their empty Bud Light bottles or cans and blow them up. And they were doing this and having a good time until the sheriff showed up, arrested them, and they were charged under Kansas's Terrorism Act for possessing explosives. And sure enough, if you look at the statute in Kansas, for the definitional section, it essentially describes possessing a explosive as possessing any combination of chemicals, which when placed in a container can generate a gas and cause a mechanical failure. This is a very broad definition. So the question was, who gets to decide what particular facts qualify for possessing a terroristic explosive device? I took the approach in a concurring opinion of discussing a very popular grade school science experiment where you take a roll of Mentos and you put them in a Diet Coke can. I don't know if you've seen this before. It's a great thing to do. It teaches kids lots about science, I presume. But what you get when you do this is an explosion of Diet Coke, right? And actually what happens in that science experiment fits the statute to a T. It generates a gas which is designed to cause a mechanical failure. So is that a violation of the Kansas Anti-Terrorism Act? It may seem like a silly question, but these are questions that prosecutors are faced with all the time, and I think it's fair to ask, did the legislature really mean to give prosecutors and maybe juries that much power to define crimes in Kansas? The second case I'll discuss just briefly had to do with our felon in a possession of a weapon statute, which defines a weapon, at least in one subsection, as a dirk, switchblade, straight-edge razor, or any other dangerous cutting instrument of like character. So if you imagine, just think of your toiletry bag. I'm thinking of that because I just flew. But in your rooms or in your bathrooms or whatever, there's a lot of dangerous cutting instruments, right? Are they all weapons that were intended to be criminalized by the Kansas legislature? In this particular case, a felon who was on probation got a job as a machinist and was asked to carry a multi-tool, which is one of those very small, it's like a folding pocket knife essentially. And he went to his probation officer and said, hey, is this a weapon? Am I allowed to possess this? And the probation officer actually said, no, the legislature didn't mean to criminalize this. Of course you can have this for your job. Lo and behold, he was arrested, found with the multi-tool, and charged by a prosecutor with being a felon in possession of a weapon. the argument was actually raised to the Kansas Supreme Court that this was an unconstitutional delegation of power by the legislature to prosecutors. And a majority of the court accepted that argument and found that, yes, this statute is an unconstitutional delegation of legislative power to the executive branch because it's so vague that it essentially allows prosecutors to, on an ad hoc basis, decide what is a crime. And deciding what is a crime is the role of the legislature. So those are two interesting cases, which I don't think oftentimes get thought of as being part of the basket of administrative law. And I'll conclude with that.
Thank you.
Well, thank you, Judge Griffith. It's great to be here. I commend Professor White and the organizers for putting this together. And I have to say, I think back to my time in law school, and some of my most delightful experiences were those dinner meetings of the Federalist Society. And I guess I was the token liberal there, and had so much fun. And the spirit of debate at those events was tremendous. So I am delighted to be here and to participate. I'm a lot less liberal now than I was then. But I still enjoy the discussions and the debate. And I have to also say that it's really exciting. I don't know about my fellow panelists, but to look out and see this many students come to a session on administrative law, because when I was in law school, I found administrative law really boring, and I didn't get it. My eyes glazed over when I did the reading. And I think part of the reason I wasn't that enchanted with the subject was the person who was teaching the session or the section that I was in had this undue fascination with NHTSA, the National Highway Transit Safety Administration. Everything was about NHTSA, NHTSA this, NHTSA that, and it just. So I think if you can expand beyond NHTSA, you can begin to see some of the interesting parameters of administrative law, and Justice Stegall has already gone, and Judge Griffith.
And wait a second, you clerked on the DC Circuit.
And I clerked on the DC Circuit. So it started to get it started to get a little more interesting. Although I would say that probably one of the least interesting aspects of my clerkship was that I had a one-year installment of the ongoing. Maybe it's still going on. The rate-making litigation from WMATA, Washington Metropolitan Area Transit Authority, is probably still going on.
I don't think it
It
is.
just went on and on.
I didn't think it was possible to do worse than NHTSA, but you just put me
I think generations of DC Circuit judges were, the judge I clerked for was superannuated, as was his surviving colleague on the WMATA panel, Judge Spotswood Robinson. And I think the third judge on the panel had died during the pendency of this latest iteration. And I think the litigation definitely outlived Judge McKinnon, who I clerked for, and Judge Robinson. But I'm glad to know it concluded before your tenure there. Okay. And also, the other thing is that, as Judge Sutton points out in his wonderful article for this symposium and the wonderful books he's written, going back to that famous son of Harvard, Louis Brandeis, we know the states are the laboratories of democracy, so it's great that the Boyden Center is putting on this panel to focus on what's going on in the states, because we read what the federal courts are doing, but occasionally they read what we're doing, and there's I think there's a lot of cross-fertilization of ideas and jurisprudence across those sovereigns. So, and as Judge Sutton's also written about, some of the doctrinal underpinnings in this area actually trace back to the state jurisprudence rather than vice versa. As one example, Pennsylvania, where I live, our Constitution is an ancestor, not the descendant, of the United States Constitution. You may not know that Pennsylvania's first constitution was adopted in 1776. Think about that. The framers of Pennsylvania's constitution were working in the same Independence Hall, that same musty, smelly, hot, windows sealed set of rooms there, no air conditioning, banging out the Pennsylvania Constitution, Benjamin Franklin et al., and years, more than a decade before the United States Constitution. So a lot of these, certainly Pennsylvania's framers were not debating non-delegation as such, but certainly there was a lot of debate about separation of powers and the various principles and structures that bring us here today. So anyways, in two of the, what I've developed in my short essay for this panel, and I won't go into detail on right now, is that in just about 6 years, the Pennsylvania Supreme Court struck down on non-delegation grounds 2 enactments, whereas in the entire time period since our New Deal, SCOTUS has only struck down 2, Schechter Poultry and Panama Refining, that a lot of you have read about. Schechter Poultry was the one with Cardozo's famous concurrence about this is delegation running riot, and those 2, of course, were still in the era of the Four Horsemen and before the switch in time that saved 9. And I encourage you Harvard students to read Professor Feldman's book Scorpions in a Bottle to learn about that era. In any event, the 2 that we struck down in just a 6-year period, one was a Philadelphia School Reform Commission case, basically Pennsylvania law, some of which is now defunct, but set up a distress mechanism so that Secretary of Education could, upon the happening of certain triggers, budgetary and otherwise, declare a district in distress, and the Philly School District was in great distress, over $1 billion shortfall, and that's 2001 when $1 billion was $1 billion, and so gave these vast powers to the School Reform Commission, and displacing the elected school board, right? And the appointees to this commission could then wield enormous discretionary power, and essentially what they did, without having to reach any discernible criteria, engage in any kind of procedural safeguards and what have you, simply suspend certain provisions and suspend actual statutory sections of our school code. So we struck that down. There was no intelligible principle. There was no procedural safeguard whatsoever. Just a year later, in a case called Protz, I wrote the majority opinion in this case and had a lot of fun with it. This case, it's just unbelievable. So the Pennsylvania General Assembly had said that, and this is workers' comp, and I know when I say workers' comp, you're like, oh, that's so boring. And believe me, I feel your pain, but in the workers' comp statute, the General Assembly of Pennsylvania had said that the impairment ratings that are going to be used by physicians evaluating injured persons will be according to the latest methods set forth in the American Medical Association guides. Basically, like, I'll have what they're having. So whatever the most recent edition of the AMA guides is, that's the impairment rating. Okay, so it was not only a delegation, but it was like a running tab. It was like whatever the AMA wakes up and decides for breakfast today, that's the law. I mean, it's unbelievable delegation, and we whacked that out. That was really delegation running riot, because again, it wasn't just what the AMA says. It's a private entity.
Did WAC appear in the opinion?
It did not. It did not. But it wasn't just what the AMA says. It's what the AMA says, like most recently, like whatever they thought today. So, and footnote here, and this is an interesting thing, we can talk about it if you want, is, does it matter? Is it a distinguishing issue whether it's a delegation to a private entity as opposed to a public one? Oddly enough, SCOTUS has, not since Carter Cole, ever indicated, to my knowledge, that there's any meaningful distinction. In fact, Justice Scalia and Professor Volokh and others have said basically there's no difference. You know, jurisprudentially, an overdelegation is an overdelegation. Much less luminous people like myself have suggested there is a distinction, but I made that suggestion 36 years ago when I was at that benighted school down I-95, where the pizza is better, but I don't know, but I continue to, we stayed away from that particular, we did not need to reach that issue in Protz, but I'm still sort of holding a candle for that idea that there's something a little more problematic when you just hand it over to a private entity, and if that doesn't bore you to tears, you can look back at volume 96 of the Yale Law Journal for this overly wordy note on private prisons. But in any event, the bottom line I came out with in looking at this was, notwithstanding the coincidence that we've had two non-delegation strike downs in 6 years, and SCOTUS only had 2 in 90-some years, the jurisprudence isn't all that different. But just one thing, and then I'll shut up because there's a lot we can talk about in the next go-round here, but I want to highlight something that Judge Sutton reminded me of in his piece, because I think it's very apropos in this area of non-delegation, and that is that many of our state legislatures around our country are part-time, poorly staffed, and you know, not in session too much. Now, some of them are frankly part-time and paid as such. I think like Texas, for example, just convenes, you know, really. But then some of us have the best of both worlds. Like in Pennsylvania, they are full-time and they are paid full-time. They're just not really there that much, and they're not doing very much. You know, and in fairness, they don't. You know, some of you have been to the United States Capitol, and you see all kinds of, you know, lawyers running around in there. Maybe some of you will be them. They're, you know, very busy staff people. Many of them are actually lawyers. You know, they have a lot of robust staffing, and the committee staffs themselves are enormous. They're vast. There's the minority staff, you know, there's the majority staff, there's the joint committee staff, and on and on and on. Eager beavers, lots of them highly trained, young lawyers, many Harvard law grads, etc. You don't find as much capacity in the legislative bodies, generally speaking, on the law side at least. I once was on a panel with one of our legislative leaders, and I asked him, I wasn't being facetious, I genuinely asked him, do you actually, I know you have lawyers there, do you actually have somebody assigned to like read our opinions and actually, you know, read them and then think about whether you should react? He didn't really have an answer, but the point I wanted to make is this aspect of temptation to overdelegate may be more pronounced in the state legislatures, in the sense that, like, you guys in the agency, just figure it out. We're just going to give you this broad power. We just don't have the capacity to really drill down anymore. Just do your best. And then they may end up regretting that overdelegation, leading to initiatives like Justice Stegall talked about to try to rein it back via a constitutional amendment. So anyway, a little more interesting than NHTSA, I hope.
Take it away.
Well, hi, it's wonderful to be with all of you today. If my face is flush and my words don't fit together, it's because 19 hours ago I was at Lambeau Field with my son, but we won't talk about the game. So Wisconsin, is really at, if you follow national politics, which I assume many of you do, we seem to be at the center of all kinds of fights. And therefore our court is at the center of all kinds of fights, and so is our legislature. And what I'm going to do here is maybe cover a few more things at a little bit higher level about some of the things that have crossed our desks, and I think that may be helpful in terms of thinking about it. I'll start with a lot of the changes that we've had in administrative law have been occasioned actually because our legislature has been pretty active. From 2011 to 2019, we had a Republican governor, Scott Walker. I was his chief counsel for about 5 years, working on some of these things, and a Republican legislature, and they passed all sorts of different reforms, among them requiring, for example, agencies when they promulgate rules to rely on specific statutory authorities saying you can promulgate it. If you're issuing a permit, you can only put conditions that are explicitly listed in the law. There was a REINS Act that was passed. If it is over a certain dollar amount of money, then you can't promulgate rules at all. There were new levels of accountability with the governor and our Department of Administration having to sign off on every administrative rule passed that actually used to go through my office, and which is a little interesting because, as I'll get to later, we have separately elected members of the executive branch, constitutional officers who are not under the authority of the governor. And then we now have a Democratic governor who won in 2018, and after that, our legislature went into a lame duck session and passed a number of laws that are still subject of considerable litigation, taking some powers away from the Attorney General, empowering the legislature to, for example, litigate and do all sorts of interesting things. But a lot of things have happened in the courts as well, and sometimes they do work together. So briefly, let me talk about kind of our experience with the issues of deference to administrative agencies. Wisconsin's approach has very little to do with the federal approach. The way we operate is nothing like that. It wasn't. So up until a few years ago, the way it worked in Wisconsin is you basically looked at how much of an expert was the agency, and did they have interpreted rules of long standing. If so, then courts, when a case came, were supposed to give what was called great weight deference, which was basically, well, we'll say what you say goes as long as it's reasonable, even if we think another interpretation is more reasonable on the law. And then if it was sort of within the agency's bailiwick and their expertise, it was given due weight deference, which is basically as long as an interpretation wasn't more reasonable, we'll let that go. And then we had some issues that we review de novo. You'll notice that none of that has anything, by the way, to do with finding ambiguity or any of the sorts of things you find in some of the federal jurisprudence. It's simply, does the agency know what they're doing, and have they been doing this for a while? If so, then we're gonna let them their interpretation go. Well, a few years ago, our court invited the parties in a kind of a standard agency case to brief the question of whether we should continue to defer to state agencies. They did so in our court. This was before I was on the court. I've been serving for since 2019. But overturned basically all of that. And so we no longer defer at all. There was an interesting split opinion. You had two justices who said we should continue deferring. There's no problem to fix here. We had two justices, including the author of kind of a lead opinion mandate, saying that more or less all that was unconstitutional. And you cannot, as a court, defer to on the interpretation of law to state agencies at all when a case comes before you. You're the court, your job is to say what the law is, therefore you shouldn't defer. Then we had three other justices who thought that was a bridge too far and maybe too broad of a statement about what the Constitution requires, and basically said, well, we kind of made up this deference thing anyway. There's no statute that says we need to defer. We just kind of started doing it, and so now we're going to stop doing it. And that's basically where it ended from a judicial side, until just a few months after we decided that, the legislature in fact passed a law and now it's codified, no more deference to state agencies. One thing I will offer on that I find interesting, because I've been going to Federalist Society events for a long time, and I was involved. I know this is a common topic of conversation. And I think these are really interesting theoretical questions, but my own experience with several years of that being the way we operate is that it hasn't radically changed much. And the reason it probably hasn't changed much is because in practice, if courts didn't like what agencies were doing, they often just kind of found a way to say, that's not a reasonable interpretation, and we're not going to let you do that. And so, for the most part, the only times that may come up is if you have an interpretation that's been around for a long time, and the court decides it's clearly wrong. And that just doesn't happen all that often. I mean, it may happen regularly. But the benefit is, now when we have cases before us, we're not arguing about how much the agency knows what it's doing. We're arguing about what the text of the law actually says. And I think that's been relatively productive. We've also had lots and lots of cases dealing with separation of powers, some issues of delegation. I don't have time to go into all of those, but let me just touch on a couple of them, and then I'm going to offer some just big picture thoughts as well. So one of the changes I mentioned is that all administrative rules had to go through the governor's office to get approved. We have a separately elected superintendent of public instruction, separately elected by the people, whom the Constitution vests supervisory authority over public instruction, which, as a brief aside, we also have a constitutional provision that vests all executive authority in the governor. I'm not sure how that all works out, but that's what our Constitution says. And so there was a litigation over that, and what our court ended up deciding after a few fits and starts was that administrative rulemaking is not executive power at all. It's all legislative power. And because it's all legislative power, the governor having some veto authority over administrative rules, even over the separately elected officer, didn't abridge that officer's own separate executive authority. And this is an interesting question to maybe ponder some more, but having worked in the executive branch and now being, in this branch, and obviously having worked with the state legislature quite a bit, I think it's a really interesting question, what exactly are administrative rules? And I don't think enough attention is given to that question. So think about, a law that says, for example, all right, go tax cigarettes, right? Your Department of Revenue, go tax cigarettes. Well, what the executive branch is going to do, or Department of Revenue, they're going to try to figure out what a cigarette is. And believe it or not, there's actually some hard questions about what a cigarette is or what a cigarette's not. Well, we have a statute that, with regard to administrative rules, that requires an agency, if they're trying to interpret a term that they're going to apply statewide, they need to promulgate a rule. And so that would probably need to be promulgated via rule. So, question. On the one hand, one could argue, well, that's legislative power because there's an element of maybe policy making that's being made when the executive branch makes that decision. So is that the executive branch exercising legislative power, that the legislative power has some ability to check through the administrative rule process, or is that actually just doing what the executive branch normally does and read statutes and make decisions on hard questions, and the executive branch is actually intruding a bit on the executive branch by telling the executive branch how it can't make the sort of normal day-to-day calls that every executive branch agency or official needs to make about what words of a statute mean. I'm not here to tell you what the right answer to that question is, but I think it's an underexplored question when we think about what administrative rules are and how it relates to the administrative state and how it relates to questions of non-delegation. In the interest of time, I'm actually just I want to just offer, I had a couple more cases I'd talk about, maybe I will going forward, but I want to just offer two more sort of global comments about these issues. So I'm an originalist and textualist, and that's how I try to do my judging. Some people are originalists because they're for instrumental purposes. They want a small government. They think originalism is the best way to get there. That's not me. I think that's actually the right way to do law, is originalism. And so that's what drives me towards it, that in terms of the nature of texts. And I think, one of the issues that we've had, and I've had in cases before us, is we've got our own constitution with our own constitutional history. And there's these sort of national movements, including, in rooms like this, where many people would love to see, 80% of government done away with, right? And if we can't get the legislature, can't get Congress to do it, we can't get president to do it, we can't get our state legislature, well, surely the courts should step in and solve that problem. And I understand that impulse. But I think an important question to ask is, and a central question, is that what the Constitution actually says and provides for? Has the judiciary been invited to step in and draw lines? And if so, in which areas have we been invited to draw lines in? In which areas have we not? Because democracy is really messy. And there's a lot of really, really hard questions that are under-theorized and that are under-explored, and for which we don't have text that tells us a whole lot. Wisconsin's Constitution, for example, simply vests executive authority in the governor, legislative authority in the legislative branch, and judicial authority in the judicial branch. Now you tell me how to draw lines in that area. It's really hard to figure out. But that's what I get asked to do when these kind of questions come. And the last point that I want to make as well is that Justice Scalia said, and whether he's right or wrong, maybe it's up for debate, but he said the rule of law is the law of rules. There's not a lot of rules that govern some of these questions. There's not a lot of good theories or things for us to hook into and say, here's how we separate the wheat from the chaff. Here's how we can say when you've crossed the line and given power from one branch to another. And maybe that's fine. Maybe we just need to kind of spitball it a little bit and do our best. I mean, you've seen things like the major questions doctrine arise. It seemed to be efforts to say, we don't know how this all fits together, but we think you've crossed a line, and so and this is a big deal, and so we're going to maybe give it a little harder look. A lot of states, including Wisconsin, have a history where questions about delegation of authority really began to arise during the Progressive era, and you see courts start to act and start to strike some things down, though using some different tools and different analytical frameworks than we have today. And then in the early part of the 20th century, begin to back off and get pragmatic about it. But I also wonder to what extent some of the debates that we've had and some of the issues that have come before my court too is an effort to be similarly pragmatic, but just more stringent. And whether we actually have some good analytical tools. I think it's exciting that you guys are here because we're at the toddler stage of thinking about this. There's so much good thinking and work to be done, history to be written, and analytical frameworks to be developed that I think are essential and really do help contribute to all of us, trying to do our jobs. I mean, Wisconsin's constitutional story is different than Kansas and Pennsylvania and the federal Constitution. But we are all birthed from the same spring in many ways, and so I think there's a lot of important questions to be thought through a lot harder and a lot further. At least for my part, I have some concern about the judiciary plowing too far ahead too quickly without thinking of those really hard questions there, lest we step out of our own lane and we run into the rule of judges rather than the rule of law in the name of the rule of law.
Sutton.
All right, thank you for inviting me. Adam, Federalist Society, it's great to be with my favorite friends in the world, state court judges. I guess I'll call you a territory judge. You're a federal judge, but it's outside of your territory, so it doesn't get any better than that. Well, I'm a little ashamed to admit, David, Justice Wecht, that I did not take administrative law. I had the same judgment you did and acted on it. That didn't look like a terrible decision for the first 15 years of my career. here because, hey, the non-delegation doctrine's never enforced in federal court. What's to know? Why do you need to know that? And Chevron seemed like it had to be a biblical truth. Justice Stevens wrote it. Justice Scalia was its foremost defenders. How could it possibly be wrong? So as a judge, you look for ambiguity, call it a day, and work on your golf game. The last 10, 15 years have just been an astonishing development in administrative law, and it's a really fun topic. I would most definitely take it today. In fact, I'd love to teach it. One of the things that's quite interesting about administrative law, at least to me, is I'm very interested in comparing what states do to the federal courts, what state constitutions do relative to the federal constitution, and I'm being a little unfair to state court judges. My three colleagues here would not do this, but I think it's probably fair to say that in most areas of constitutional law, the instinct of many state court judges historically has been to start with the assumption that whatever the federal doctrine is probably what the state doctrine ought to be. That has certainly been true in individual rights. It doesn't prove you can't rebut the presumption. It doesn't prove you can't find something in the state constitution that proves there ought to be a different take. But the federal language, the federal doctrine is so dominant, there has been that tendency. Now, I do think the last decade has shown some change in that area. But what's fascinating to me about state administrative law is everything's flipped. The states don't seem to have any interest in federal non-delegation. They don't, so many times, don't even talk about it in Chevron terms. It's almost strange to see a state court agency deference case invoke Chevron. And so it's just interesting to me, why this difference? Why have the states been leaders rather than followers, and why administrative law? And I have just a couple possibilities. Maybe it's something we can talk about. But one place to start is that the state constitutions not only imply separation of powers with separating in different articles executive, legislative, and judicial power, but almost all of them have the John Adams 1780 Massachusetts Constitution's explicit guarantee of separation of powers, saying that, for example, the executive branch shall not exercise the legislative power. It's hard to ignore when you're thinking about Chevron. It's hard to ignore when you're thinking about a delegation problem. It applies, by the way, all the way around the circle. So that, as a textual matter, whether you're originalist or not, that ought to give you pause, and perhaps that's influencing things. Justice Hagedorn referred to the possibility that you'd have a plural executive, which is the norm in the states. So you have separately elected executive branch officials. Now try to think, how does Chevron work, right? Let's just stick with AG and governor. Almost every state has a separately elected AG and governor. What if they disagree? Who's the Chevron figure? Why would it necessarily be the governor over the AG, particularly given all the authority that says the AG is the top legal official in the state? In fact, that problem right there illustrates the very thing they were trying to get at in Chevron. Is it legal or is it policy? If it's policy, you would say governor. If it's legal, you'd say AG. And the reason we have Chevron, the reason Scalia defended it for so long, is you could never know exactly what the problem was. In fact, in the Ohio case that just came out and was editorialized today in the Wall Street Journal, this exact problem happened in the case. General Yost took one position as to what should go on and was pushed the idea that the state constitution prohibited Chevron at the state level, and the governor defended the agency, no surprise, and took the opposite position. So Chevron's a strange concept, and I would say plural executive affects a little bit the delegation debates. I mean, you could imagine, maybe you should cut the other way, but you could imagine from an accountability perspective, when there's a delegation to an agency where the head of that agency is separate elected, you might think a little bit differently. Now, just because there is a plural executive doesn't mean there's not a single state in the country where the whole cabinet is filled just with separately elected officials. So it's usually Ohio's typical AG, Secretary of State, Auditor, and then of course the governor. But separate election, that would seem to have an impact. How about the fact that 90% of state court judges are elected, 75% of the states have judges? The reason the two differences is California has a lot of judges and it has elections. So one of the issues one of the explanations for Chevron is accountability. Well, that suddenly looks a little different if, you've got elected judges who are actually making the calls and people have a resort there. Another way to think about this isn't my idea, it's Aaron Sager's idea, is state court judges are quite different from federal judges in this respect. We federal judges, or at least, stingy people like me, think we shouldn't be doing common law, we just have to stick to the statute, or we have to stick to the original meaning of the Constitution. Boy, does that flip in a state court. They are told to do the common law, and the common law is policymaking. No one thinks it's not cost-benefit analysis of what is the best rule for this contract situation, assuming the legislature hasn't codified a rule. But if there's no codified rule, that's what the people are asking these judges to do, to find the best rule. Well, judges that are trained to find the best rule, it's understandable, first of all, how they might think about constitutional interpretation differently, whether separation of powers or individual rights. But you could also see things being a little different when it comes to their authority to decide, well, we're going to tell you what the law is here. This is what we normally do. So I'll make one last point because I want to get to broader questions. It's not just interesting that the states have not followed the federal lead. Is it actually possible, I would never think a federal judge would follow a state, we're too proud for that, but it is possible we federal judges might have something to learn from the state experiences. And one thing that seemed to affect Justice Scalia, formalist and originalist though he was his concern with non-delegation, that it was going to be very difficult to figure out a principle that would tell you when there's just been too much delegation versus, just enough to be constitutional. And he was just very troubled by finding a principle that would work. Now I will say what does support him on that front is the state courts that use all kinds of language. Some use the federal language. Pennsylvania is a good example, intelligible principle. But they're all over the map with their language. No one's got a eureka test. So in that sense, I must say Justice Scalia was right. So no one has figured out a test where everyone says, oh yeah, that's easy to predict and see how it's going to work. But even though they're using similar linguistic tests, they're clearly enforcing the non-delegation doctrine way more. I mean, I think it's 16% of the cases at the state level versus 3% at the federal level, so just a lot more. The Pennsylvania example illustrates this. And this goes to Scalia's other concern, that the sky really would fall, that it was really going to create implementation problems. And if the sky would, if that's true, of course Justice Scalia would never think to look at state court experiences, being a product of the DC Circuit, or DC-centric, federal-centric world. He would have been able to see that the state courts, the sky did not fall. And it's worked out just fine. Sure, there are some cases where it's a little harder to figure out why they enforce it there and not there, but it didn't really create a problem. And the same thing with not using Chevron, which is a concern, I'd say, of other scholars. Not using Chevron is somehow going to be really difficult to continue to administer all these statutes. That's just not happened. The states have gotten along just fine. States that have gotten rid of it constitutionally, see Mississippi. States that get rid of it by statute, see Wisconsin. The sky's not falling. It actually just forces the legislature to do its job, which maybe is not a terrible incentive to have today. So anyway, great to be here, and on with the questions.
So, first of all, is any responses or questions that you might have of each of
We
us?
should get some other people
Should we do?
involved, yeah.
Okay.
Let them.
Okay, we'll turn the time over to the students. We have a couple folks out here with microphones, right? And so, first question. First question. Right here. Brandon, can you?
Hello, gentlemen. My name is Brandon Sharp. As Judge Sutton just mentioned, that it seems like the states are leaders on a lot of these issues, but I'm so interested in hearing your thoughts about how persuasive how do you use federal law? Do you give it Skidmore type deference? Does it really depend? Obviously, it depends on your state constitution, but like, how do you use federal precedent? Justice Stegall, when you were talking about the deference to prosecutors, I was thinking about our deference and Seminole Rock deference, but I don't know if that is applicable in your state. So I'm interested in just hearing how you use it.
Yeah, so with respect to Chevron, Seminole Rock type deference, Kansas is one of the states that has rejected that completely. And this was roughly 12 years ago, our court had followed the traditional sort of, essentially the Wisconsin approach of we won't disturb it if we can see our way to saying it was a reasonable interpretation of the statute or regulation. And we went the opposite direction to say, no, it's the role of the judiciary to say what the law is, and we are not going to sort of abdicate that role when it comes to interpreting either statutes or your own regulations. So that has been the practice in Kansas for the last 10 years or so. Interestingly, when it comes to non-delegation, Kansas is on the opposite end of the spectrum, where we have a very lenient non-delegation doctrine. In fact, you might say it's non-existent. The criminal cases I talked about earlier are the only cases that I know of, at least in our modern history, when our court has found a species of non-delegation, a violation of non-delegation. For the vast majority of cases, we've never seen a delegation that we really didn't like very much. A cynic might suggest that we take a robust approach to protecting the function of the judicial branch, to say what the law is. We take a much more nonchalant approach when it comes to policing blending of legislative and executive power. I do think that is a phenomena that might bear some examination, because as I said earlier, and I think Justice Hagedorn mentioned this as well, you can never lose sight of the fact that judges are public officials as well, functioning in our tripartite system of government. So we are not sort of neutral, overseers refereeing. We are participants in the game at the same time as we're called upon often to referee, which vastly complexifies the question. I'm not sure if that answers your question,
But I guess just if I can follow up, do you see that as persuasive, the Seminole Rock or our deference, or did your state constitutional law kind of refrain you from looking to this federal law?
My own view would not give very much deference. I wouldn't even call it deference to federal law and interpretation of the federal Constitution, unless what we are doing is applying federal law or the federal Constitution. But I would take the same view as I think I heard Justice Hagedorn express, which is Kansas is one of those 51 imperfect solutions. We have our own history, which is very unique, and our own Constitution and our own language, and it's our responsibility to interpret and apply Kansas-specific constitutional or statutory rules. And with apologies, I don't really care what the federal.
Go, John.
I wanted to add on this I'm generally unreceptive to agency arguments that purport to command my obedience. I basically, my attitude to them, as to any litigant, is convince me, don't command me, right? So the argument from authority, I think, is always I tend to be suspicious of it. I think it's often a hint of weakness. That there's a lack of analytical heft to the argument, and therefore, my refuge is a demand for your obedience, judges. I do think that our is obviously a different question than Chevron, and I think it's fair to say that you can make a stronger case for our than you can for Chevron. At least the case can be made, right? Because statutory interpretation, it's what we do, right? So if you're an agency and you're directing me to obey your interpretation of a statute that you didn't write, there's a disconnect there. If you're urging me to to fall into line with your interpretation of a rule, hopefully a rule you didn't just draft in the course of litigation, which SCOTUS has poo-pooed since 1988, rightfully, right? You could see it as a different animal, although I'm skeptical of our as well. I just want to point out one other thing, that Professor White's colleagues, Jennifer Mascott and is it Mr. McManny? I forget his first name. Eli. So are they here? Are they here? I don't know if they're here, but I don't know them. But they wrote a wonderful review essay in the Wall Street Journal back in August of a new treatise by Professor Merrill of Columbia Law School on Chevron. And they pointed out something, a number of things that were interesting. I just wanted to say one thing apropos of this that I thought was very incisive is that you may be seeing in the silent distancing by SCOTUS of Chevron, that this like a desuetude that basically it's going into obsolescence and eventually will be overruled. Maybe I'm wrong, but that it seemed like an interesting point that if you look at the SCOTUS decisions, I mean look at West Virginia versus EPA, they're just steering away from invocations of deference, aren't they? Right? A Kaiser watered down hour, right? But they're basically not even going there. And on my own court, I've written concurrences and dissents saying, hey, there's this deference body of law, let's talk about it. And my colleagues also don't seem to want to go there. It's interesting because Professor White's colleagues in that review essay analogized it to the Lemon test in the Establishment Clause jurisprudence. And I kind of liked Lemon, I'll say that, but it's gone now. But the point they made, I thought, was an interesting one. It's just like for years, SCOTUS had been dissing Lemon by implication. Now they basically just came out and said goodbye, Lemon. So that may be what's happening with Chevron. After years and years of just going around it or avoiding it or not going there, it's just basically gone, maybe, or gone, and then eventually it'll be tossed. So,
I don't know if there's a moderator's prerogative that I can ask a question, but I want to ask Justice Hagedorn the experience in Wisconsin where the state legislature intervened and said no deference to executive branches. Can you tell us a little bit about how that developed? Was that a political dynamic behind that, and what role, if any, the courts played in that process?
Sure. Well, so the decision that I referenced before, where the court, where my court decided to stop deferring.
That came first.
That came first, and then. That was in 2018 or early 2018 or maybe late 2017. And then there was an election in 2018 and the political power switched, which is not an insignificant part of the story because our legislature called a lame duck session and, like I said, made a number of changes. And certainly one of their motivations was they did not want the Democratic governor to have the same kind of authority or make sure that authority was kind of cut off. And that applied in a number of different areas. But I do think that there's, there are some, public interest law firms and others that are doing some thinking in this area that make calls, and there are people in our legislature who care enough to try to pass something like that into law. So it was part of an actually omnibus series of bills that were passed in a very short period of time with very late night negotiations with nobody really paying attention to them until they happened and the litigation about other issues commenced. And like I said, it's still going on because, like I said, they took a bunch of authority away from the governor and the attorney general and did that as well.
Yeah, I just find that interesting for the obvious point because all the action on Chevron deference at the federal stage is going on in the writings, in the chambers of Justice Gorsuch and his colleagues, right? That's
Yes.
where the real energy is. And I wonder if this is an example of, well, maybe it ought to switch over to the Hill, to Congress. I don't know that that's possible.
There were is a bill that's been proposed in Congress to get rid of Chevron. Isn't that right?
Yeah, there have been a couple bills like that bouncing around in the House. They usually get thwarted in the Senate.
Yeah.
I should add that our statute does say, giving some measure of due weight to the unique expertise of the agency over a subject area, but not in the legal question. So I think when they're making factual findings, we even had a lot that sort of ferreted that out, but the statute clearly says you can't defer on a question of law.
Suppose they had done that the other way around, if I could just ask. Suppose, Justice, that instead of passing that law after your court made its decision, the legislature had done that in advance. Would that offend you from a separation of powers perspective at all, that they were telling you how to decide? It's something apropos we were talking about before.
Yeah. Well, it's a good question. In that case, that was the debate that happened among my colleagues before I was there. There were two justices who I think would have said, too bad, so sad. We're the court, it's still our job to not defer regardless of what you say. I think three of my other colleagues were not there. They're not all still on the court. So I don't, I'm not sure what my answer to that question would be, to be honest with you. I think there's some hard questions there.
Is that really what you would think? I mean, if the legislature says, we don't want you deferring to agency interpretations of law, I'm trying to struggle with why a court would be troubled by that. That seems strange.
I can think, I have colleagues, maybe one at least that's retired, but a number of, I can easily see
He would say,
state court
he or she
judges
would say the Constitution of
saying-
Kansas requires deference?
No, saying it's none of the legislature's business to tell us how to do our job. So the question of deference is a question of judicial, it's kind of a common law-ish question.
It's a really
That's the way it's
interesting
been treated, and that's why I appreciated your comment earlier that state courts function oftentimes, it may not be explicit, but there is a culture of common law judging and common law rulemaking, even for rules that govern our own processes. How are we going to decide cases? We get to write those rules.
That's why it's a funner job than a federal.
Let me just read, if I may, that the colleague I'm thinking of, Justice Johnson's his name, wrote in 2013, our court abandoned deference, agency deference in 2009, and several agencies kept coming to the court and still arguing deference. And Justice Johnson got frustrated at one point, and in 2013 wrote that we unequivocally declare that the doctrine of agency deference has been abandoned, abrogated, disallowed, disapproved, ousted, overruled, and permanently relegated to the history books where it will never again affect the outcome of an appeal in Kansas.
And then the legislature later came
And it
along
was after
shot it.
that, no, it was after that the legislature codified.
Yeah, they
They
came along.
essentially did what happened in Wisconsin and codified in our, Administrative Appeal Act.
Yeah.
So just to bring that to a conclusion, so a lot of states codify, this is for the students, a lot of states, the legislature will codify rules of interpretation, which is so different from the federal model, including saying things like, you can use legislative history, you can use purpose. And that implicates this question of which ones of those implicate separation of powers. So if the legislature, say, got rid of the rule of lenity, I'm pretty sure most state courts would say, you're outside your lane, that's a constitutional rule. And I guess that could happen potentially, I was thinking it would only happen in the direction of a legislature that's insistent on deference. I'm not sure they're allowed, I could see, obviously your two colleagues in the Tetra Tech case would have said, no way, separation of powers prohibits. But I wasn't thinking the other direction, but maybe that's possible.
It's, I'm not sure that there's a really satisfactory answer. Perhaps there is, I guess we could think about it, but you have the template across America where the model law writers gave them statutory construction acts, and the state legislatures picked and chose if they wanted to adopt them, and if so, in what form. So we have ours, of course, and they tell us there, they tell us certain things like you may use legislative history, for example. and you may do this. So there is a question of how far up to the line can they go in directing us interpretive methodologies. I guess there's, we'd know it when we saw it, I guess, right?
Yeah, I mean, sometimes they define things. What does this state mean? What does he mean? It can be very technical, but probably some of them implicate separation of powers, I would guess. Yeah.
Yes, sir.
Hi, thank you all for being here. My name is Thomas Nielsen. So I have a question with respect to the non-delegation doctrine. One of the reasons, as I understand it, the federal courts have struggled to or declined to enforce it is because of their inability to fashion meaningful standards to police that sort of issue that could be applied in an objective way across cases. For those of you whose courts are expressing an interest in a more robust non-delegation doctrine, how are you handling that problem, especially given maybe the differences between your state governments and the federal government?
Well, I don't. In the two cases I mentioned, I don't think we developed any breathtaking new methodology. Obviously we don't have anything besides Shepherd Poultry and Panama Refining to go on, but the basic separation of powers principles and the intelligible principle rule of procedural safeguards. I did mention in my essay that we've gone a little further in articulating the necessity for procedural safeguards than SCOTUS has done, but I don't think there's any magic to it. And when it's a blank check, it's a blank check, and I think it offends. But I also think it's sloppy lawmaking, and that's why I mentioned a point about not that Congress does good work, they don't, but they do have more staffing capacity and more lawyers on board, and so when they do actually pass a law, which isn't that often, they actually have had a few more lawyers' eyes on it, perhaps. Maybe I'm being too charitable.
I would say as far as dealing with the problem, the only way we're dealing with it right now is essentially arguing with each other about it. In Kansas, I'll just, if you'll allow me just to read this briefly, this has been the rule in Kansas on non-delegation for 150 years now. From an 1871 decision written by Justice David Brewer, who served on the Kansas Supreme Court in the 1870s and then became one of the four horsemen of the apocalypse on SCOTUS. And this is what we've said, that the legislative power of the state is vested in the legislature alone. The legislature cannot delegate any portion of that power. However, it's generally found impracticable for the legislature to exercise the power in detail, so the legislature can mark out great outlines and leave all who are to act within the outlines to use their discretion in carrying out the minor regulations. That's the rule in Kansas. I have said numerous times, look, this is Katie bar the door. This is anything goes, and thus far I've not been able to convince a majority of my colleagues.
Let me ask Judge Sutton, are you aware of other states that have developed a more muscular approach to non-delegation doctrine?
Yeah, so I asked Kristen Hickman this. So she's from Minnesota, a really great scholar in this area. So first of all, I'm going to change the question a little bit, but for I think a good reason. Chevron and delegation, they're really the same thing, right? I mean, non-delegation deals with explicit delegations, and Chevron's about implied delegation. So it's the same, you could argue, same underlying problem. And what Professor Hickman was telling me that she thought worked quite well is doing things like this, that maybe you should never have deference in an adjudicative setting. Only deference in a rulemaking setting. That doesn't strike me as a terrible dichotomy. And then she said, because this gets to one of the worst parts of delegation, states will put, through their APAs, much tighter leashes on rulemaking. So they will say, okay, fine, we can't do it, see Justice Brewer, but you got 60 days, and that's it. So you either do it or you don't do it, and as opposed to this world in which agency, new administration goes back, forth. So they give this tight, it's not tight in the sense of scope, it's tight in the sense of time and an immediacy, which strikes me as quite useful. And then they're stuck with it, and then the only way to change it at that point is the legislature. So it keeps the legislature in the game. So those are ones I've heard that make a little more sense, but it is, so even Pennsylvania, which is using it more, still uses intelligible principle. You know,
In Wisconsin, we use some similar language, intelligible principle, you know, some need some substance to it, and then procedural protections are often enough, so we've not had much of a robust non-delegation doctrine. There's been more cases that have started to explicitly invoke it, but quite frankly, we haven't had, at least in my view, any sort of real grappling with, you know, kind of our own constitutional history and what that should look like. There were some attempts during some of the COVID stuff, which is, you know, interesting and challenging. And we had a statute that, you know, empowered, for example, certain officers to forbid public gatherings when there's a communicable disease that comes in. So, is that too broad? Is that not too broad? Another part of it said to do what is reasonable and necessary to stop the spread of communicable disease. Is that too broad? Is that not too broad? What does that empower? What does it not empower? These are just really hard questions. So my short answer to that is I think there's an interest on our court. I know there's an interest on our court in at least taking it more seriously. I don't think we've gotten much of anywhere in terms of figuring out what that is. And you know, some of it goes to this question, people talk about delegation just with, what is legislative power? I mean, what is that? Are you just talking about policy? Because the executive branch makes some minimal policy decisions all the time. You have to, whether you charge a crime or not, is in some sense a policy decision. You know, if you have you know, rape statutes, but you might choose not to charge, you know, the 18-year-old who slept with a 16-year-old, you know, girlfriend or something like that. There's certain kinds of decisions that are entrusted to the executive branch, or, you know, places where they need to figure out what statutory language means. So I at this point, I have not heard a lot, you know, and that's, you know, part of my pitch is that I think there needs to be a lot of good, you know, kind of first principles analysis and some more thinking about what that would look like. Because that is why the courts gave it up 100 years ago. They gave it up because they couldn't figure out what to do about it, and partially because they more or less acquiesced to the administrative state. So are we going to get rid of the administrative state, which, by the way, might mean getting rid of all administrative rules? Sometimes our non-delegation challenges are strengthen the hand of the legislature by making administrative rules more robust, which is interesting to think of that as a response to a non-delegation problem. So there's just a lot of thorny questions that I think need to be worked out. We don't have any good answers yet.
Thank you.
Maybe one more question.
Okay, one more question. Yes, right here.
Hi, so this goes back to the question Brandon asked earlier, and I know major questions doctrine was mentioned briefly up here, and West Virginia was mentioned as well. And I'm just curious, as state justices, what pulse do you have, and what discretion do you have to kind of look at the way the wind is blowing in federal kind of interpretations and federal deference, and especially with kind of the recent, whether it's a blip or a new doctrine, the major questions doctrine as announced in West Virginia, just how does that impact, you think, what states do, how states look at kind of these rapidly rising and maybe seen as sudden shifts and departures from previously existing Chevron or other things like that?
I think Justice Stegall has a ready answer for you.
Yeah, it's a good question, and it's very understandable given the lay of the land of the legal landscape in America. But it is an important insight to take away from this, at least if I have anything to say about it. That from a state perspective, especially in a state like Kansas, and this is not a nonpartisan, it crosses all ideological lines. It's a very strong independent streak, and that question would just sound like sort of like a foreign language, essentially. The litigants don't argue federal law. It's not briefed. No one is looking at it, essentially. So for better or worse, right? And there might be a worse to that as well. But that's the lay of the land in at least one state.
That's really fascinating, because I like that, but that's not what we have. I have consistently written please make arguments based upon the Wisconsin Constitution, and I'm not getting them. Please make originalist arguments. I really want that. I mean, I've said that very directly, and I don't get them. So I actually find one of my frustrations is we get a lot of briefing that look like, hey, did you see what Justice Gorsuch wrote in his concurrence? That was awesome. Why don't you guys do that? We call it Wisconsin constitutional law. So I do think we will get something that will explicitly cite major questions and ask us to do something just like that. I'd be surprised if it doesn't happen next term.
But what will you do with it?
So I mean, I think some of the broader questions are implicated by what's happening in the major questions thing, so maybe they at least are relevant in that sense. I agree with Justice Stegall that what the federal government does is of no moment to us, other than its persuasive value for doing our own analysis.
Yeah, I agree. Again, one of the great values of this program, I think, is a reminder to students at an elite law school that most of the law in America is state law, as Chief Judge Sutton has repeatedly wrote. But I mean, when you're at Harvard Law School or the Yale Law School, everything's all federal, and none of you great students apply to work for us, you know. So, but most law in our country and most courts and most judges are state anyway. So federal law doesn't bind us unless it's SCOTUS law on the U.S. Constitution, right? So other than that, we're not bound, but we can be persuaded. I mean, you can give me a case from the Virgin Islands or the Mariana Islands or the Sixth Circuit. Certainly, that's on another level. There have been cases in Pennsylvania over the years that have said in administrative law we follow federal precedents. We don't write that anymore. That's like sloppy language from the past. So we can be persuaded, but we're not. I certainly don't feel bound by it. There's no reason, right, why we should be bound by it whether it's a constitutional or any other matter. So we're not. And apropos of what Justice Hagedorn just said, that is so apropos in the criminal area. I know we're not talking about criminal law here as such, but we have our own Constitution, and people fail to recognize that the U.S. Constitution is a floor but not a ceiling. So you can make a case that your criminal procedural rights are greater, or some other substantive constitutional right for that matter, is greater by virtue of our own charter. I'm sure, so, but people they phone it in and they don't make it, and you can have an ineffective assistance of counsel, arguably. So anyway, there's a totally different world of law out there. Harvard Law students, it's called state law. Check it out.
Can I make just one?
I had one thing. First of all, they're applying to you guys. I've told them about all you guys. And I've told them it's a better clerkship than working with me for sure. That's not saying much. I'm going to come at your question from a different angle, but I think one that's relevant to the conversation. So, I'm still in my own head working out the major question doctrine, how it works for federal statutes, what exactly is a minor question, and when exactly may I have a lawyer, I think beginning of the argument say, well, this is just a minor question, so a different rules apply. But if I were to defend the major question doctrine, and I've written opinions that embrace it pretty wholeheartedly, it would be on the line that, okay, fine, get the language, get the dichotomy to the side. What's really driving it is a skepticism of deference to federal agencies with a lot of power. And the part of the major question doctrine that is very sensible given this conversation relates to incentives, and particularly the interest groups. If at the federal level, delegations are not monitored, whether implied or explicit, what interest group wouldn't want to go to the federal government to have one agency set the rules for the whole country? Particularly in a world where if you go through the states, you've got to deal with the fact that they do enforce the non-delegation doctrine. They don't have agency deference. So talk about incentives for one agency capture. I would call it malpractice not to want to do that. And then, best of all, get a rule that preempts everything else. So when you want to ask yourself what happened over the last several decades, it's the fact that we have a bunch of rational actors facilitated by sometimes irrational federal law or not appreciating the consequences. But when you see the two systems together, it really makes sense that the federal one should start by saying, wait, do we really want to incentivize this? Particularly once they learn what's going on at the state level. So I think it's a really, I do think they're right. I don't think you'll see too many states applying major question doctrine, partly because it grows out of federalism, which would not apply to a state. But I think it's really relevant to why this court seems a little skeptical and perhaps why they should be a little skeptical. I think the incentives are very dangerous.
With that, we thank you for your questions. Thank you for your participation.
And give the final word.
The final word?
Yeah, just a few quick points of thank yous and then 2 logistical points and we'll get out of here. So first of all, thanks to Adam White for pitching the symposium to us. It was a really great idea. We're so excited to publish it. Thanks to Ben Ponce, who did a lot of the legwork pulling this together. And most of all, thanks to our judges and justices for coming all the way out here to be with us today. So thank you all. 2 logistical notes. We're going to publish the videos later this week on our website in case any of you want to write about it or have a reference point. And then articles will be published, including a few, or at least one from a justice who wasn't able to make it in March or so. So thank you all for coming. We hope you enjoyed it.
Thank you very much. Thanks a lot. See you later.
I understand.